So welcome everyone to our webinar today on dealing with trustee changes. My name is Aaron Dunn, and this session today is to help you understand many of the different and varying aspects that you might confront within your SMSF clients where we see a change that is required to either the individual trustee structure or where we may need to change the directorship or even shareholding within our corporate trustee as well. As part of today's session, we are not only going to take you through some of the technical considerations, we are also going to share with you many of the documents that we have created, but are also continuing to work on that will assist you to navigate through many of these complex or arrangements that have complexities is probably equally apt there as well. And if you do have any questions as we go along, please feel free to ask as well. We naturally need to put our disclaimer in. We do have some technical content, obviously, that we're covering in today's session, so you know the rules of engagement on that front. So what are we going to cover today? So what I wanted to start with is to help you understand the different trustee changes that you may confront when it comes to your self-managed super fund clients. We'll then undertake a bit of an assessment of the different changes to trustees. So we've come up with just a few different scenarios, whether it be just removing a director or whether we may be switching from individuals to corporate trustees, which is still one of the most common arrangements we see from a succession point of view. We'll look at things in respect to incapacity, and we'll also look at things in respect to the death of a member to give you some key insight and to understand what we need to do at a trustee level. Now, there are different aspects which we're not going to be talking about today, maybe in the event of a death of a member where we need to not only deal with trustee, but member level issues. We will touch on it, but not go into great detail. Today is very much focusing on the trustee elements of these potential changes. And as I said before, we'll go through and we'll explore how you can order and what documents are available at this point and what we're continuing to build to be able to support you via our Smarter SMSF platform. So that available document suite, and then some key takeaways from today's session for you. So without further ado, let's get stuck into and understand these various changes that we see within self-managed super fund structures. So what might we see within our SMSF client base that could require a change to the trustee? Now, I touched on just before, succession is one of the most topical and most current things that we continue to see through these change of trustee process. Many of you are fully aware of the differences between individual trustees and corporate trustees. And as we are getting a much older demographic of SMSF clients, share some statistics with you. Only 5 or 6 years ago, only 2 to 3% of all self-managed super fund members were over the age of 70 years of age. That number has now skyrocketed to around 28% of all members now being age 70 and older. So things like succession now fit front and center with many of those clients. And if you've just seen the announcements today from the Labor government and looking at different things around higher balances above $3 million and the taxing rates of those, all of these succession type things are all going to become even more relevant for a lot of your high net clients as well. So individuals to corporate around these succession things are a common thing that we see. The other one is that we might be simply adding more people into the fund. Of course, from the 1st of July, 2021, we've seen that definition of a self-managed super fund change from 4 to 6 members. So all of a sudden, we may be bringing in additional family members or other parties into this fund, and therefore, subject to the structure of that arrangement, we may need to be adding them in, not only, of course, from a membership point of view, but from a trustee and or directorship standpoint. The other ones here, of course, around loss of capacity. So where someone has a legal disability and we need to have someone appointed, so that enduring power of attorney to act as that legal representative for that individual. We'll spend a bit of time looking at that today. equally around the death of a member. And both of those, of course, have some specific requirements set out within section 17A, subsection 3, that deal with the timing and what we need to do to ensure that we have an ongoing complying superannuation fund. And finally, the other one that we would see from a trustee structure point of view is where we see individuals that may move overseas. So the residency issue comes into play. And yes, there is a temporary absence issue there that we can obviously understand and adapt ourselves to. Central management control being temporarily for a period of up to 3 years. The government was proposing to extend that to 5. But as soon as there's that permanence issue of the departure of Australia, that 2-year or 5-year, what it may become at a future point in time, is very much irrelevant. We need to be putting in place the appropriate structure to ensure that the fund continues to meet the definition of an Australian superannuation fund. So they're just a few of the various ways that you may come across changes that need to occur in respect to the trustee structure. So when we think about those changes, what we do also need to understand is that we have some responsibilities to ensure that we are updating and notifying the various regulators in respect to those changes. So with ASIC, as we know, in particular, where we have a corporate trustee, we have that obligation to report any changes within 28 days. And that equally applies in respect to the ATO as regulator, where we have changes of detail. So again, changes to membership, changes to trusteeship of the fund. We have that 28-day timeframe that we would need to adhere to too. We may have other reporting requirements. So if we are seeing a change to the trustee, we're moving from corporate to individual to corporate, or vice versa even, we may have obligations therefore to report to other bodies, statutory bodies, like the Titles Office, to ensure that we are satisfying the ownership requirements in 409A to ensure that we have adequately represented the correct ownership of those assets inside the fund. And finally, I guess what else we need to consider, we are clearly continuing at all times to ensure that we meet our definition, as I touched on earlier, section 17A, and the exceptions that may sit within that as well. We're going to our trust deed and our company constitution from a procedural aspect. So what are the things that we need to do to ensure that that change has been done validly and therefore won't come into question at some point in the future? And that is 2 parts there, the very essence of what we want to also focus on here today to ensure that we're not going to end up in situations under a potential estate being contested or the superannuation benefit being contested and things such as changes then becoming unstuck in the context as to who could make those decisions and then the validity of the documents that may have been supported thereafter as well. So let's start here with what we see as a common document, and this is changing to a corporate trustee. Okay, so this is where we may have individuals. You may be picking up a client for the first time. They have individual trustees already, and you say, we see the benefit here from a succession standpoint that we are recommending or suggesting that we change the trustee structure for all the benefits that you would be fully aware of to make that change, in particular around single member funds at a future point in time, and simplicity around asset ownership throughout periods of incapacity or death and the like. So one of the things that we, and one of the very first things that we must do is ensure that we understand who has the powers to approve such a decision. So what you can see here is on the right-hand side is Rule 29 of the Smarter SMSF deed. And there are 2 parts you can see highlighted at the top there, and they are setting out these 2 key questions that you need to be asking yourself. So who has the powers to approve the decision? Is it a power that rests with the trustees and the trustees solely? Does it rest with the trustees and the members? Does it rest with the members solely, or are there other parties that must also approve any change to the trustee structure? Founders are very common, employer sponsors, participating employers, those sorts of things. If you do not follow what the deed says, then any change that is made is in essence invalid. And then what we also need to do once we've stepped through that decision is we then need to see how that decision needs to be made by those relevant parties. Is it needing to be done by deed? Can it be done by resolution, or is there some other way in which that can be achieved? So all we need to do here is go to the very first sentence that we see in Rule 29.1. And the first line makes it abundantly clear that the trustee is the one at any time where they do it by deed can make the amendment. So what we can see here is that the power to approve the decision is by the trustee, and any change that we're going to do from individuals in this instance to a corporate trustee would have to be done by a deed. So a deed of appointment and retirement in this instance. Okay, so if we look at it at the very bottom of the screen there in Rule 29.2, if we were looking to change the name of the fund, so kind of different to what we're talking about today here, but that change could actually be done by way of resolution where the trustees approve to do so. So understanding the type of document that the governing rules say is critically important and at some point in time may be tested. So get the accuracy of that information becomes absolutely paramount. So then we say, if we're going to be making this change, one of the common things that I see regularly with our deed updates is making sure that we have a match between what decision-making says with your deed to the decision-making of your company where we implement, I should say, that corporate trustee. Quite commonly, we see people upgrading their deeds to a Smarter SMSF deed, which is fantastic. We obviously think our deed is the best in the marketplace there. But what we have inside the deed may be very different to what is inside a constitution because you haven't looked at, or that individual, that firm hasn't looked at the constitution maybe since it was established 5 years, 10 years ago. So this is where commonly we see in discussions with people who upgrade to our deed to say, well, our deed talks about, if we have a look at Rule 24 on the bottom of the screen there on the right-hand side, if you go to 24.4, it says each decision by a member at a member's meeting is to hold that number of votes equal to $1 per vote in respect to their superannuation interest. So it means if Dad here has $1 million in the fund and there are 4 other members in this fund, let's say it's a 5-member fund, and the collective of them, they only hold 800,000, then Dad, by a simple majority, because he has the highest balance, will be able to control that fund. Now, that may be appropriate in the circumstances, it might not be. But if we have a corporate trustee in place, that is in essence totally irrelevant to the context of decision making because we need to go to what the Constitution says. And in instances I have seen where the Constitution talks about those decisions of meetings that need to occur is done by a vote in which each director has 1 vote. So using my example where Dad had the lion's share of the money in the fund, he could then be outvoted 4-1 simply because we did not have alignment of the Constitution back to the fund's deed. So you can see here in our Smarter SMSF Constitution in Rule 10.6, at a directors fund meeting, a proportional voting rule is to apply where each director or alternate director is to hold that equal number of votes in aggregate in respect to the member's superannuation interest that he or she holds, or in essence that they are representing for someone if there is a representative acting on behalf of another person due to incapacity, death, residency, or other means. So making sure those 2 things are aligned is critically important. So what do we need to then action if we are making that change to the corporate trustee. Now, some of you at our SMSF National Conference last week, I did a lot of work around the topic of what's called besieged by documentation, and getting process right in this kind of revised age of more digitized SMSFs is critical, because the first step that we'll need to do is ensure that we have director IDs obtained at least 1 day prior to the appointment of them as a director. So that's a requirement under Section 1272C of the Corporations Act. It does enforce the appointment at least 1 day prior. So getting your director ID 1 day prior to the appointment. So that is signing the consent to act as a director. So we have a process that you can see here, and very deliberately, we need to get our director ID first. We need to then consent to act as a director. We then need to incorporate our company, in which we would be looking at a special purpose company for obvious reasons, because it is only to act as the trustee of a complying superannuation fund. The reason why we have our special purpose trustee, because it deals with issues like LPRs stepping in the event of incapacity and allowing an alternate director for those type of arrangements. Now, we would be then looking at our ATO trustee declaration, if that hadn't already been done, potentially previously with the individual trustee. And then we have our Form 484 and our change of trustee details with our ATO reporting. So it's not simply kind of going, what documents do we need to get lodged and the job is done. This is really about saying, what do the rules of our fund, what do the rules of our company say? And therefore, we need to ensure that we follow the rules that govern the operation of that company and fund. So you'll see throughout these slides today, I've got some little asterisks there. These are things that you can naturally order via our Smarter SMSF site, or they generate as part of an order. So our ATO trustee declarations, they will generate when you do a thing like a change of trustee, or even with our new funds and those sorts of things. So let's jump into our first one here and have a look at the change of trustee with that deed of appointment and retirement. So I'm going to go across, make sure I get all the right screens up. So naturally in here, we've got 70, 80 documents plus now, and you can search over this in respect to a change of trustee, for example, and you'll see in here, in the first instance, we now have listed a range of documents around deed of appointment and retirement, death of a member. We've just added in our removal for incapacity, which we'll talk about more shortly. So what if I just go into our change of trustee form here? We're not going to spend a lot of time looking at the forms per se, I guess. What I really want to do is just take you through and understand some of the differences between the particular forms, and then we'll have a look at the output that relates to that particular form as well, because what we do have is the ability for you to go away and have a look at these sample documents in your own time as well. So what you can see here in this change of trustee form is really there's 3 or 4 parts here, but we've got our change of trustee detail in there. We've got our meeting, we've got then the ability to review and submit. But what you've got here is a choice of 6 different combinations. So we are looking at individuals to company. We can revert back from company to individuals. We may want to only do a deed of appointment to add 1 or more individuals, which you can do. You can also reduce the number of individuals by a deed of retirement or removal. You can add and remove at the one time, and you can then switch from one company across to another company. So it may be that you've got a non-special purpose company and you do create a special purpose company. So we've got all those combinations that are attached in here. Equally, as I spoke about before, we've got in here the decision and the powers as to who is the one that is to be undertaking and allowing for that appointment and or removal in respect to that fund as well. Okay, so these are some of the additional things that we've built into this. it naturally looks at whether there's been adjustments previously. And we've got our tool tips in here to help you go through the deal with in the deed, that removal and that retirement. So again, you can kind of fast track your way through there as well. But what we end up with is this, just make sure I've got this up still, so hopefully you can still see this page. But we have our change of, sorry, that's the wrong one. I want to go over to here to our knowledge base, I should say. What we have then is our sample documents. So you'll be able to go in and you'll be able to look up the change of trustee document. And then you'll see in here, we have our sample that in this instance here, we just bring this up a bit higher, larger, so you can see. And increase that. So here we have individual trustees, and we have now appointed our new trustee. Okay, so we have our process around the change and what needs to occur. And then, of course, we have our provisions around the removal, the release of that retiring trustee, the covenants made by that trustee, the appointment, the acceptance of, and the consents, and then just some interpretation. And ultimately, that has been signed off. So whether there are additional parties, whether they are like an employer sponsor, those sorts of things, that information can be added into here to ensure that those that need to sign are signing, again, to ensure the validity of that particular arrangement. And again, we'll produce the relevant trustee minutes, resolutions, to ensure that that information has been adequately prepared as well. Also, the consents to act as trustee. So in this instance, now we have both parties here, John being appointed, Kathy being appointed as a director, pardon me, as a director as well. And then our trustee declarations here for them that they would need to sign if they hadn't completed those as well. So we'll pre-populate this information so that it saves you time and allows you to keep moving with what you need to do as well. So that's in essence all there for you to be able to access through that generated order. So let's switch back to our slides again and jump into our next one. So the other one here is ceasing as a director and member. So again, I'm not going to spend on all of these combinations, but again, what we're looking at here is trying to understand how can a director be removed, or are they retiring? Again, is it done by deed? Is it done by resolution or otherwise? Now, one of the things that is really important to remember is if a member is departing a fund, are they simply leaving? And what actually happens when they leave? Of course, we know that we're rolling over the benefits and we would cease them as a member of the fund. But one of the things that we have within Rule 13.6 of the Constitution with Smarter SMSF is where that shareholder is no longer a member of the fund, then we actually have a forfeiture of their shares inside that trustee company. So we don't have any obligation within Section 17A to ensure that shareholding needs to be equal or needs to be representative of all of those that are inside a fund. But if you've wound up members and in essence they've left the fund, what has happened in respect to their shareholding? Have you gone and removed them? Or what does the Constitution say in respect to their shareholding in the fund? And therefore, have we done the reporting to actually have their shareholding removed at the same time? So in this instance, as you can see, it's very deliberate. We don't want them being involved in that company anymore. Not only do we want them removed as a director, but we don't want them to have any powers, any decision-making powers at any point in the future. So we simply cut them off by having those shares being forfeited, but it does require us naturally to have to report that information. So we're required here to obviously deal with membership. So we're looking at the deed itself. So we're looking at cessation as a member. One of those, we've got the adding and removing member documents on the Smarter SMSF platform. We've got our super stream rollovers and lump sum payments that would need to happen. And again, we've got documentation to support those things. We have reporting that needs to be done in respect to that member. So they're now moving from the fund, ceasing as a member. So we have to lodge that information with the regulator within that 28-day time frame. And as I said, we need to deal with the director and the shareholder rules. So we're going to our constitution. Are we looking at it in the context of cessation as a director? In the instance of our Smarter SMSF documents, it's the forfeiture of shares that would occur. And then we have reporting of ASIC to ASIC, I should say, in respect to those particular changes as well. So again, there's a number of things that we need to step our way through. And if I go back here, I might just close that one there. We would, oops, sorry, wrong one. So if you ever want to go in there, just go to the knowledge base, close that one, I should say. And we can go in here and type deed of retirement. And you'll see in here, we've got our deed of retirement document. And again, steps you through what is included in that particular deed around the fact that we have the individual that is no longer acting as an individual trustee of the fund. So here we have Jack as the retiring. We've got Scott, Alan, and here inside the fund, the retiring and continuing trustees we're looking at here. We've got different amendments. The retiring trustee intends to retire. We confirm all those decisions. And then naturally, off the back of that, we would have the retiring trustee signing, being witnessed, and we have our continuing trustees that would obviously continue to exist and operate in the fund. So again, we go through those procedural aspects, and then if there's any other documentation that needs to be supported beyond that, we would naturally do that as well. But we want to ensure that if the member is leaving and they're leaving as a director, we may then be needing to understand what our constitution says and updating our share registers and those sorts of things as well. So let's keep moving on. And let's have a look at these couple of really interesting ones around incapacity and death of a member, because it's quite interesting. We're having conversations multiple times each and every month now about how we deal with an older individual who has now lost capacity and the obligations of meeting the requirements set out within section 17A 3B that you can see there. Okay, so what we have and know in the fund is that the change occurs at a director level, but the individual is remaining as a member of the fund. Okay, so that's the first thing. We also have to contemplate whether those shares are being transferred or not across. So let's just quickly, before I jump onto that, let's look at rule 5.4 here. So a person may not act as a director where he or she is under a legal disability. We know that to be the case, and that sits within section 17A, and they would need to be removed or resign at the time of notification or awareness of any legal disability or within a reasonable period thereafter. Okay, so if we have an LPR, then that LPR may be appointed to act as a director, as long as they're not disqualified, of course, and they're able to act in that capacity. They consent to act. So again, we're thinking about the documentation there, and they ultimately do so. And then again, we're following Rule 5.2 and 5.3 of the Constitution. A director prior to resignation may also appoint an alternate director, where the alternate director is that director's LPR, and provided they're not disqualified from doing so as well. So these are the steps that we need to follow when we are preparing documentation to support an appointment of a director where we have that corporate trustee in place. Now, similarly, if we have individual trustees, then we need to step through and look at what the deed says around the appointment of that LPR. But we are in essence following what is set out within 17A 3B. Now, from a shares point of view, like I said, if we look at 13.5 here, if an LPR is entitled to shares because of the mental incapacity of a shareholder, it gives the directors the information they reasonably require to establish that LPR entitlement. then by giving that written and signed notice to the company, they elect to be registered as the holder of those shares, and that person is entitled, whether or not registered, to the same rights that was attached to that particular individual. So what do we need to do and contemplate here in respect to dealing with someone that has lost capacity and ensuring that we continue to comply with our SMSF definition in section 17A? So first thing, appoint our EPA. So we need to ensure that we have an enduring power of attorney, and the enduring is critical here for the definition of section 17A. So we have our appointment of the EPA as an alternate director. Again, the EPA must have their director ID prior to the consent to act. So they may, if they don't already have it, then we need to have that in place. We need to have the ATO trustee declaration, again, if that hasn't already been completed, and we need to lodge the relevant forms, our Form 484 to change the company details, and our ATO reporting around the appointment of that replacement or alternate director there. So again, a number of these documents we now have available on our Smarter SMSF platform. If you're looking at enduring powers of attorney, we can also arrange for those to occur through Hill Legal, that naturally provides our back-end legal support to the Smarter SMSF platform. So what is an alternate director? So some of you may be acutely aware of what an alternate director does. Some of you may not, but let's just have a look at the definition here to help you understand. So an alternate director is a person who has been appointed here by virtue of the Constitution as a director of the company on behalf of a member or deceased member according to the rules of the company pursuant to the superannuation laws, including the LPR of the deceased member, the LPR of the member where the member is under a legal disability because of age, so a minor, mental incapacity, or for some other reason, the LPR of a member who holds an enduring power of attorney, or any other person who may act as an alternate director under the superannuation laws. So it is broad there, as you can see, but in essence, what we have here, and this is one of the documents that we've only just released on our Smarter SMSF platform, is that we have now created a form that deals with the, just make sure I get these all right, deals with incapacity itself. So I might just quickly refresh that page. So you'll be able to see in here, removal of director incapacity. So we've got this form now working in beta. We just want to make sure we get our integrations and that sort of stuff done as well. But the idea behind this is that you will be able to indicate who that individual is. I'll quickly go through and do this to get to the next page. So what we want to ensure that we are showing here, so we've got our Smith SMSF, number of directors that are attending the meeting here. So we'll have 2. So we'll have John and Jane. So what we're identifying through this order process is who are the people, or who is the person A that has lost capacity, and then who is the person in the fund already that may be then acting as EPA for them, or is there someone else that's coming in here? So if we say we've got Bruce Smith is the one, we're looking to through 5.4 with the existing constitution is rule. So how many EPAs does Bruce have in this respect? So we have through SMSF ruling 2010/2 guidance that allows for 1 or more attorneys to be appointed and still meet that definition. So in here we might say it's 1. Is that EPA then already a director? So this is probably one of the most common scenarios you're going to get, where rather than having 3 members in a fund, which we might have here, we only have 2 members, mum and dad, and mum is the EPA for dad and dad is the EPA for mum. So in that instance, we could go yes, and we're choosing one of the existing parties. So all of a sudden, Jane, in that example I was talking about before, Jane is looking after her husband. So she's now wearing two hats in the fund. She's a trustee for the purposes of her own membership, but she's also acting as EPA for her husband as well. Now, we could say no here. And then what that is allowing for you to do is then to add in another party. So it might be a child or children potentially as well. Okay, so again, stepping through each of these different stages and then will allow you to generate. Now, quite clearly, you're not having that member who has lost capacity sign that particular document. So there is recognition in the actual document in here. If we go up to our sample document, incapacity here. So if we look at our removal of director one here for incapacity, what you will see is where we've got writing as the LPR, that the member is being removed due to that lost capacity. The fact that the individual holds an EPA in respect to that member and the date of that, and that there are various steps that need to be looked at. So here we're looking at the notice for resignation due to that lost capacity. We're looking specifically to the rules of the fund around directors that are under a legal disability. We're then looking at the appointment rules that give us specifically how an LPR can be appointed, where they hold an enduring power of attorney, and that we have our time frame that needs to be met within 6 months to ensure that we continue to meet that SMSF definition, and that the fact that that appointment of that individual, that they're not disqualified and would render it a non-complying fund or a non-SMSF, and that we have obligations that we need to report to the various regulatory bodies, including ASIC and the ATO, and those resolutions that follow thereafter, and the confirmation of those decisions. Now, again, there may be some additional steps here, consents to act. There may be also obligations around the trustee declaration as well. But there, again, you can see here, there are a variety of things that we need to cover above and beyond just simply saying, oh yeah, we're removing someone, we need to get our ASIC report done so we don't get fined. As you can clearly see through the Constitution, there are particular steps that we need to work throughout that process. So again, we're asking these as you work through that, that form. So a couple of questions. Eleanor, what happens if only one director has lost capacity? We may have ourselves a very, very big problem. We may need to actually go to court to resolve that issue. So one of the things we may want to do is ensure that we have the automatic appointment of someone. So putting in place a director, an alternate. Some deeds have what they call succession directors. So in the event that someone has lost capacity, there is an automatic appointment of that particular person. Okay, but otherwise, really, we'd need to go to the court and have the court give us direction to allow for that change to then occur, unless you've got some other shareholder in the company that would therefore allow for a shareholder decision to be made to have then someone appointed to start taking over the fund that way as well. So yeah, it can become hugely problematic, and part of the reason why you need to get the building blocks in play now to ensure that we don't end up in those sort of situations. But yeah, that's a fantastic question. All right, let's keep moving, because now the other one I wanted to touch on was in respect to the event of a member's death. And as we said before, there's some trustee level decisions that need to be made, and there are also some member level decisions that need to be made. And today is not about jumping into many of those member level decisions where we're talking about, you know, components and pensions and all those sorts of things. From a trustee level point of view, what we're looking at here is, again, the potential appointment of a legal personal representative to deal with the death benefits. Now, what I should say is, if you go into section 17A3A of the SIS Act, there is, the way that the law is drafted is that it is permissive for that legal representative to be appointed, but not mandatory. So therefore, we need to be going back to the rules of our fund and our trustee company to understand whether the replacement of that deceased member must be appointed or simply has the opportunity to be appointed if they consent to do so. Okay, and again, we have our replacement trustee rules that we need to comply then with Section 17A within 6 months to meet and continue to meet that definition of a self-managed super fund. So before I jump over to some of those rules there, again, from a member level point of view, there are additional things that need to be done. So what we're doing from a Smarter SMSF point of view is we're finishing off these trustee level things around incapacity and death. And then from a death point of view on a member level basis, we already have things like payment of a reversionary pension. We have death benefit pensions. We've got some element of lump sum, but we'll be putting more, again, some more meat on the bone around the death of a member and the steps that need to be taken or that you can take through to ensure that we satisfy that requirement. And then this suite of documentation that we've now built will help deal with the trustee level decisions that need to occur there. So again, from a trustee level, we need to contemplate both the death of the director member, but also the death of the shareholder. So from 5.1 there, where a company acts as trustee and a member dies, at the request of the member's LPR being the executor and subject to his or her consent. So again, it's permissive but not mandatory. So we don't have to bring that other person in if we've got binding instructions and we know that that money is simply going to flow out. But it may be prudent to have that individual appointed, and then naturally we're going to have documentation done around the appointment of and then the removal of that individual once that death benefit has been paid. Because as you can see there in 5.10b, at the commencement of the payment of the deceased member's death benefit to his or her dependents or one of his or her legal estate or representative director, they then must resign at that point in time. So we may have a point where we may have an appointment and then a resignation that needs to follow. And each of those have not only procedural things that must be adhered to in accordance with the Constitution and or the deed, again, subject to individual or corporate trustee. We then must report those within the relevant prescribed timeframes to the appropriate regulators. From a shareholding point of view, if a shareholder dies, the company will only recognise the LPR of the deceased as being entitled to the shares. And then naturally we go through that process around the shareholding and again, written notice of that and the fact that they have the same rights as the deceased shareholder at that point in time as well. So we are currently finalising the form in respect to building out the death of the member with a corporate trustee in place, but we do currently have already our change of trustee deed in respect to the death of a member. Okay, so again, the difference here, we have our change of trustee form for individual trustees and whether we are adding or removing and that sort of stuff. We have a different form that deals with death of a member with individual trustees. We are also building a separate form to deal with change of trustee for incapacity, and we will do the same in respect to residency. We may add that in as an additional item into the existing change of trustee form. We'll wait and see from that point of view. But what you will see in here is it will indicate the member's death and that information in the other fields. I'm not going to bore you with the details here. You can go in and have a look there. But what we will go and have a look at here is the change of trustee, and then we have our death of member document. So again, we have a range of things that we are generating for you in this process. And if we just go a bit higher, you can see we have our deed of appointment and removal, recognizing the death of the member. So we have the member itself, we have the continuing trustee, the new trustee. We recognize that Jill was a member of the fund and a trustee, and we include the date of death there, and what the rule within the fund prescribes around their removal upon death. The continuing trustee is to continue, within a period of 6 months from the date of death, the new trustee must be appointed. And in essence, this is what is being confirmed here. So we are utilizing this, I guess, following on from the payment of the death benefit and ensuring that we comply with that section 17A thereafter. So again, following on the new appointment, the obligations of the continuing trustee, the acceptance of that appointment, some of the definitions, and then the execution of that. And the decisions that are happening within the fund about the confirmation of that member's death, the compliance with the definition, the appointment and the approval thereafter, and of course our consents that follow for that new individual that is coming into the fund, again, along with our ATO trustee declaration. So pretty comprehensive for you to work through, but all of this is naturally leading itself back to the governing rules of the fund or the constitution that sits here where we have a corporate trustee in place. So what do we have from a suite of documents? So hopefully today I've given you a bit of insight into the deep and vast suite of documents. So let's just confirm again, we have our change of trustee. So what that allows you to do is to appoint individual trustees through our deed of appointment. You can remove individuals through a retirement. We have our deed of appointment and removal. So we are removing individuals and adding individuals in. We are changing and removing individuals and adding a corporate trustee. We are moving from corporate trustees back to individuals, or we may be moving from a corporate trustee to another corporate trustee. Now, if you have a member who has died, where we have individual trustees in place, you are not using the change of trustee document, but you're using the death of the member. You cannot have a dead person sign that document. So clearly, the change of trustee death of the member is relevant here because we are referencing the SIS regulations and having the LPR and that appointed person or that replacement person signing those relevant documents as we spoke about. We are working on our incapacity here with the enduring power of attorney, so that will follow shortly. And on the company side, so where we have a corporate trustee, we now have our changes to director form. So we have adding a director. So if we're simply adding someone in, including alternate directors, we have the removal of a director. Again, we may be removing alternates there as well. And we have adding and removing a director, again, including those alternate directors where appropriate. As I showed today, we have our removal of a director due to incapacity, where they are under that legal disability, and we are working on our death of a member at the moment. So I suspect we'll have that available in the next few weeks, and then the removal of a director around the residency rules, so our EPA requirements as well. So I don't think you'll find a suite that comprehensive in the marketplace. Again, if you have anything that is unique to those circumstances, quite commonly we kind of build to the 95 or 98%, but there may be some nuances in it. There is an opportunity for us to obviously work with you to go through and address those nuances as and when required. But yeah, it's a fairly diverse set of documents, but these are the diverse set of circumstances that now exist within our self-managed super fund clients as well. So some key takeaways for today's session. So it is really important about getting it right with the changes to your trustees, because if you don't, and you don't understand how it can be done and the order of what needs to happen, you put at risk much of the work that has been put in place thereafter, because of the fact that we actually haven't followed what the law and what the governing rules require us to do. A greater number of clients, therefore, within our SMSFs, and I'm sure you are seeing this yourself in your own practice, we certainly see it on our own platform, they are requiring changes with their trusteeship or with the directorship due to things like incapacity and death, but also just simply in the identification of greater succession planning that we are seeing within the marketplace itself. And what do we do at Smarter SMSF? We are dedicated to obviously working with our specialization that we have in this industry. And we'll continue to do so and continue to build a complete suite of documents that support these different changes that we see occurring in an SMSF each and every day. So we do thousands of documents year on year on year, and we have conversations every day with our SMSF clients about particular issues. And when we start to see these recurring things come up, it's when our nimbleness of what we do in our business to pick these issues up and then build them into documents that can be used each and every day. And hopefully today, we've been able to highlight to you what we have done in this space and what we'll continue to do to be able to support you. So thank you. As I always say, smart people do learn together. We've got a number of sessions coming up from a CBD point of view. We also have our quarterly update in April around what else we've been working on in the Smarter SMSF platform, our TFN and ABN integration, Supermate, these documents, and a whole range more. And of course, we will be going around Australia in the not too distant future with our SMSF Day events. Both myself and Tim Miller, our new SMSF Technical and Education Manager. So have a look on our website, smartersmsf.com/events. You can see what is coming up. Other than that, thank you once again for your time today. It has been much appreciated. We might have a look at some questions online, but otherwise I hope to see you at an event in the near future. Take care and bye for now.